You're listening to the Today's Family Lawyer podcast, the leading source of daily news and insight for family law practitioners in England and Wales. Sign up to our free weekly newsletter at todaysfamilylawyer.co.uk and subscribe to hear all the latest news and views from across the family law sector. You can also follow us on LinkedIn and Twitter.
Hello, welcome along to the latest Today's Family Lawyer podcast. Today I'm chatting about the current direction of travel around non-court dispute resolution, no longer alternative dispute resolution, quite importantly, and the changes that are coming into the courts system pretty imminently at the start of April and towards the end of April as well. I'm joined by Marc Etherington. Marc is the legal director at Rayden Solicitors and is also part of the National Committee for Resolution. Thanks very much indeed for joining, Marc.
No, thank you for inviting me. I really appreciate it.
First question is pretty straightforward. If you wouldn't mind telling me a little bit about yourself, please, Marc. Who are you? What do you do?
Well, thank you very much. So my name's Marc Etherington. I am a family lawyer. I'm also a collaborative trained lawyer as well. I sit on Resolution's National Committee, having been elected in 2023. Before then, I was co-chair of the YRES National Committee, so representing the junior members of Resolution. I also sit on some other committees, being the Parenting After Parting Committee, the Wellbeing Committee, and I also sit on the London Region Committee. And in terms of the office where I'm based, actually, by the time this podcast gets released, I'll be based at Rayden's Hampstead office in London, so I'm part of their London team.
A world exclusive.
Absolutely. Yeah, there we go. So yeah, it's from 1st of April. Yeah, you've heard it here first.
Topic of conversation today, as I say, non-court dispute resolution. We're talking about some of the changes that are coming up, which are going to be implemented in April, and just the general direction of travel around NCDR. And I guess the first question I wanted to ask you, which is probably a bit of a big question, but I'm going to ask it anyway, is are we making some progress on this? There's an awful lot of conversation happening around mediation, arbitration, alternative routes to resolution, but it still feels as though we've got a big problem in terms of the court service. It's still oversubscribed and we're still going to court.
Yes, absolutely. I think, first of all, the court system is really struggling at the moment. Families going through the court process, it's brutal. It's brutal for the families, and it's actually brutal for those that represent them as well, because they're very stressful, very expensive, and decisions are being made by a judge, a complete stranger. I think the way we work has changed a lot over the last 10, 15 years, where very much everything was very litigation focused 10, 15 years ago. So there's been a lot of discussion about finding alternative ways to help families away from the court process. So I think there has been a change of direction, but up to this point, I don't think the movement towards non-court dispute resolution has been drastic enough. Hence why I think the new rules that we're going to discuss a little bit later on are quite significant. I think judges are trying to do what they can. Hence, I think with the last couple of years, we've started to see cost orders being made more frequently when a party behaves unreasonably in litigation. And I think, again, judges have done that to discourage being unreasonable and using the court process to behave in a certain way. There's a long way to go still, I think, and I'm really hopeful the forthcoming rules will bring some much needed change to the profession in terms of how we work and support families across the country.
There's almost a give with one hand and take with the other approach at the moment, because it was widely documented that mandatory mediation was by and large rejected, the Law Commission proposals. But on the other hand, you've had £170 million worth of funding in the budget just a couple of weeks ago. You've got the extension of the mediation voucher scheme. There are the Pathfinder trials going on as well. I don't really understand what the government's approach to this is in many respects.
I think actually the government is listening to key stakeholders, such as resolution, for example, because I think actually all the political parties, they thought the solution was mediation. Solely mediation is the solution. And I think they see the benefits of mediation, hence the mediation voucher scheme, which I think has been around since about 2021. Clearly, from the research that they have done, the government, they've seen that it does work. Hence, they've invested a further £15 million into the scheme. And I think per couple, they've got a £500 voucher scheme for joint mediation meetings. And that scheme has been extended to run until April 2025. So mediation is very useful and it's a very powerful tool. But you can't force somebody to do mediation because mediation has to be a voluntary process. And I think now the government and again other political parties recognise that actually it's not just mediation, there's other options out there, and that's why hence they've invested 170 million. Now actually 170 million, whilst it sounds like a lot of money in terms of the budgets that the various government departments have, it's not a huge amount of money at all, but it's a start. And with my resolution hat on, it's interesting because it used to be resolution were trying to get the politicians to listen, but now it's the politicians that are actually approaching resolution and saying, what should we do about this? So, for example, the Labour Party appear to be quite in favour of cohabitation reform. And I think that's come from listening to resolution and its members. And with resolution, for example, we offer training for mediation. We offer training for collaborative. We have a number of committees focused on non-court dispute resolution, whether that's the Parenting After Parting Committee, the Dispute Resolution Committee, and we have a collaborative working party as well. So that's really, really positive. And you mentioned about Pathfinder courts. Now, I don't know a huge amount about it because I know the initial trial took place in North Wales and Dorset, but certainly my understanding is that the main focus there is for the voice of the child to be heard much sooner. And so what is being undertaken under this Pathfinder is a child impact assessment, whereby CAFCAS speak to the child or children and the parents much earlier in the proceedings, as well as other agencies where appropriate. So the idea of that is the voice of the child is heard much sooner. And the feedback that the president's had is that from parents, from judges, from practitioners under this scheme, is that it has worked very well. And it's my understanding that the president is very keen to extend that trial out nationally across the country as soon as possible. I'm also part of a group of small family practitioners where we are currently working on a project whereby we are trying to see how the voice of the child could be heard much sooner in cases that are not going through the court process. And so I think on that point, it's maybe a watch this space moment. And it may be, you never know, me or one of my colleagues on that group may be able to give you more information about that in a separate podcast. But that's quite exciting. But yeah, the court system is, as I said earlier, it's not great at all. And actually, I've got cases in London and outside of London. And London's not too bad, but there are certain regions outside of London where the court system is really struggling. So anything that we can do to make things better for families and for those that work in our profession is hopefully going to be a good thing for everybody.
I've spoken to a few people on the podcast and sort of more generally through the publication about training and about understanding what opportunities there are out there. You mentioned, obviously, that resolution are very active in this space. Is there enough of an awareness of the non-court dispute resolution opportunities that there are?
I think from my experience, I think junior members of the profession are aware of it. But the question is, for some of those individuals, is actually being supported by their supervisors and being supported by their firms to undertake that training. The collab training at Resolution, off the top of my head, I think that's about £1,000, a flat rate of £1,000 for 3 days training. And I recommend every single family practitioner should be doing the collab training. It's a great way in working. Mediation is much more expensive, but I know there's an appetite, certainly within the junior members of the profession, to do this training. And it is for, I would say, the more experienced members to perhaps support that. And potentially, maybe with these new rules coming in, there will be a greater focus on that type of work. So the information's out there, the training's available, but it's for people then to actually undertake the training and to do it, which is going to make a difference. Because when I did my collab training, oh my God, it opened my eyes. And even in my cases where I don't have collab cases, I still work in a different way now in terms of the language I use, how I approach cases, trying to pick up the phone to resolve matters rather than sending correspondence. So training is absolutely key.
Well, it's felt as though we've beaten around the bush long enough around these new rules. So the Family Procedure Amendment rules come into force in part on the 8th of April and then again on the 29th of April. Can you just explain to listeners what they are and what they mean, please, Marc?
Yeah, absolutely. So under the current rules, which is pre-8th of April 2024, the Family Procedure Rules 2010 in parts 1 and 3 makes it very clear that the courts have not only had a power, but also a positive duty to encourage and facilitate the use of non-court dispute resolution where appropriate. Yet, in practice, that duty has often been simply, just ignored or underused. So the whole idea of these new rules, which is called the Family Procedure Amendment number 2 Rules 2023, is to try and bring more focus in ensuring parties make the best use of non-court dispute resolution, otherwise known as NCDR. And that's why the Family Procedure Rule Committee was asked to look into this and to see what they can do, and hence they came up with these new rules. So just to give you a breakdown of, for me, some of the key points. So from the 29th of April 2024, the definition of non-court dispute resolution will be widened to mean methods of resolving a dispute other than through the court process, including but not limited to mediation, arbitration, evaluation by a neutral third party, such as a private financial dispute resolution process, and collaborative law. So what that means is, whilst the definition has provided all those options as a non-court dispute resolution, which interestingly includes arbitration, if new ideas come up, they can also fall under the definition. So, for example, one method that I'm aware of is what's called the certainty project. It's a combination, essentially, of mediation and arbitration, where the arbitrator makes the direction, says you've got to do this by this, and this date. They send them away for mediation, try and resolve it mediation, and the issues they can't resolve at mediation, the arbitrator then makes a determination on. And then Family Procedure Rule 3.9 subsection 2 will be amended to impose a requirement for MIAM providers to, and I quote, indicate to those attending the MIAM which form or forms of non-court dispute resolution may be suitable as a means of resolving the dispute and why, and provide information to those attending the MIAM about how to proceed with the form or forms of non-court dispute resolution in question, end quotation mark. So basically what that means is that, you know, I think with MIAMs, there had been a perception that it's all about mediation, and it shouldn't be. The whole point of a MIAM, and those that are able to undertake a MIAM meeting, is to explore all the non-court options that are available. And I don't think that applies in practice, really. And I think that's why there's been a focus on that. And so hopefully that will ensure there's greater scrutiny on the MyAM providers to make sure they are giving the right information in that regard. And now another key change, so the new Family Procedure Rule 3.3, subsection 1A, will provide that when the court requires, a party must file with the court and serve on all other parties in the time period specified by the court a form setting out their views on using non-court dispute resolution as a means of resolving the matters raised in the proceedings. So what that is going to mean in practice is that the court will require that this form will be filed digitally in cases which are managed by the online portal, which is currently Financial Remedy and some private law children cases. And therefore, each stage of the proceedings, every time there is a hearing, there should be some form of document statement on the court file that a judge will be able to look at to see what efforts that have been made to explore non-court dispute resolution. And the idea is, if the judge finds out that one party has not made a genuine attempt to explore non-court dispute resolution and engage in that, then they could be liable to a cost order being made against them. And so there is focus at each stage of the proceedings that non-court dispute resolution has to be at the forefront of everybody's minds. And there's another significant change as well, is that so from, again, 29th of April, an amended Family Procedure Rule 3.4 subsection 1A will say that the timetabling of proceedings allows sufficient time for these steps to be taken. The court may adjourn proceedings to encourage parties to undertake non-court dispute resolution. So the reality was, under the current rules, the court really couldn't force parties to explore non-court dispute resolution without their consent. But now the agreement of the parties is no longer required. So if a judge is of the view that a particular case should be using a non-court dispute resolution method, the judge can then make a decision on that and actually direct the parties to do so. That is significant, really, especially when we could have a situation whereby if you don't make a genuine attempt to explore these various options that are available, you could be subject to a cost order.
Fantastically comprehensive, Mark. Thank you very much indeed for that insight. I guess the question that comes to mind is, do we think this is going to be effective? The onus is going to be on the judiciary to really implement this. And as you said previously, they don't always follow that line, do they?
You're 100% right. I think the only way is that this is going to work is if the judiciary really takes advantage of these new rules and imposes them as much as they can. Now, the impression I'm getting from certainly the High Court judges is that they are really in favour of these new rules. And so there was a judgment by Mrs. Justice Knowles in the case of X v Y, which was a High Court judgment on the 17th of January 2024. It was a big money case, finances. I think the capital was about between 27 and 29 million. And it had been projected that to go all the way to the final hearing, the legal fees jointly of both parties would be 1.1 million. And so I think the judge made it very clear in that particular case. Well, I read the judgment as the judge essentially wanted to send a message out to the profession and say, look, these rules are coming. You have been warned. You have to adhere to them. If you do not, there will be consequences. So in one part of the judgment, Mrs. Justice Knowles actually says, if you fail to engage in non-court dispute resolution without good reason, will mean a departure from the general starting point. There should be no order as to costs. And what the judge also said with that particular case I mentioned is that she said if these FPR rules had been in place, she said it would have justified her adjourning the hearing in order for the parties to engage in non-court dispute resolution. So I'm anticipating once these rules come in, I think there are going to be a couple of judges that are going to bring out some judgments quite quickly in regards to applying these rules. And that obviously for most of us who deals with cases before, magistrates, district judges, circuit judges, you know, they are bound by the decisions made by the higher courts. So I'm optimistic. I think this really could make a huge difference. But I think all of us have a role to play. I think we've really got to focus on this. And in my cases at the moment, what I am doing is I am sending a letter out to those that are representing the other party and saying to them, look, my client wants to do mediation. My client wants to explore the collaborative process. Look, if we can't resolve these matters, would you agree to arbitration? And then I am specifically making reference to the new rules, because what's going to happen is if the other party does not engage, then if we go to court, I'm going to be waving this letter in front of the judge saying specifically we have approached this in the right way in encouraging a non-court dispute resolution approach, and we'll be asking for costs. And so I think that has to be, you know, the way we manage our cases moving forward.
Strikes me there are a couple of things that would really help or really make this change effective. One is a series of rather statement decisions and rulings. You can see you nodding along.
Yes.
Yeah, definitely. Second part is this preemptive onus on solicitors, as you say, to be prepared to come along either to mediate or to explore non-court dispute resolution right at the outset. And as you say, then ensure that's evidenced if at some point it has to go any further. It's a really interesting change in dynamics, I suppose.
Yes, and look, potentially this could be a significant change. Look, there are many practitioners out there who do try to find the best solution for families. But look, I've come across cases, and I'm sure it's the case with others, where you scratch your head sometimes and you do not understand why a court application has been made at a particular stage. Like for me, in terms of financial cases, for example, if you need someone to make a decision, arbitration is a no-brainer, unless you've got serious issues of non-compliance or maybe disclosure issues where you can potentially see, look, you need intervention from a court. You may need certain court orders, for example, third-party disclosure order. That I kind of get. Or it's, you know, maybe you need a legal services payment orders. There are certain situations when court intervention will be required, but in the vast majority of cases, it's not needed. It really isn't. And I'm always a great believer as well. If you're able to settle your case during the court process at any stage before a judge makes a final decision, that probably highlighted that actually you could have resolved it away from the court process in the first place. If you have a case that goes all the way to a final hearing and a judge makes a decision, you probably look at it and say, you know what, no matter how hard we tried, they were just never going to agree. So, as I said, hopefully it's going to ease the pressure on the court system, which is what we talked about earlier. And then that means the judges can deal with those really important and urgent cases more quickly than they can do at the moment.
I'm going to swap hats and I'm going to put my devil's advocate hat on, because two things come to mind. First is this is like turkeys voting for Christmas. As you say, you know, in the case that you referenced from January, this firm potentially is going to lose over £1 million worth of fees. The second thing that comes to mind is there's a risk here that we go too far, that we try and settle disputes outside of the courts when in fact it would have been more prescient to take them into the courts.
Yes, I think, and that comes down to, I think, the experience and the knowledge of the practitioners who are managing the cases. to know when non-court dispute resolution is appropriate or not. Of course, things like maybe domestic abuse, maybe one obvious example. And also the judges as well. I think the judge just getting a feel for the case and knowing actually, yes, can this work? Can't this work? It includes arbitration. So, and arbitration in theory is quicker. It's quicker. You save money because things are dealt with much more quickly, even though you're paying the fee of an arbitrator. And I just think opposition to this way forward, it's, no disrespect, but I really do think they're clutching at straws because, as I said at the start, it's about serving the families. And if we can, save money for clients in terms of the fees they incur and provide a kinder and better way in dealing with disputes, then that is the way forward. And look, the way I've always worked from a, maybe marketing point of view, you may suffer, commercially short term by having less litigation. But if you deal with cases in a more cost effective and efficient way, your clients are going to be grateful for that service that you've provided. And they're going to recommend you to other people because of the service that you've provided. I've got a couple, some cases in the past where, my clients have spent a lot of money, done a great job, but I know potentially if they know people who need to go see a family lawyer and they say, oh yeah, Marc was great, but I spent X amount of pounds to achieve that outcome, that's probably going to scare people off. So I think there is a commercial and business sense to approach the cases in the right way and to embrace the change rather than fear it.
We're heading rapidly towards the end of the discussion, Marc, and we've really covered off the bones of what I wanted to cover off with you today, but just wanted to finish on this final thought about the changing language that we use around non-court dispute resolution. It used to be alternative dispute resolution. We're dropping that moniker now, though, aren't we? And this is becoming much more mainstream, albeit, as we've talked about in the course of the discussion, there's still work to be done.
Yeah, absolutely. And I think the idea of removing the word alternative is that, yeah, exactly. I think having it mainstream, and it really should be the idea that non-court dispute resolution is your first port of call in terms of how you resolve the family disputes, and the court process is the last resort. They shouldn't be an alternative non-court dispute resolution. It just should be the first thing that's on your mind to deal with the matters. So yeah, I said I quite like the definition. It can be phrased in a number of ways, but non-court dispute resolution, as I said, non-court, I think clients will understand that, saying, right, it just means exploring a way that means us avoiding going to court, because 95% of the people we act for, they don't want to go to court. They see what it looks like on TV, and which obviously is not always a reality. But the idea of just going to court and having to see a scary judge to deal with your family situation is very daunting. And this is what I think society wants, really, a better way to resolve family disputes. There's been some fantastic webinars, articles, all on this subject. And I just think it's really important that anybody listening to this podcast, please look up the new rules, make sure you fully understand it, because there's no avoiding it. It's going to be here, and I think it's going to be adopted by the courts. And let's crack on with it, and let's do what we need to do to, as I said, achieve the right outcomes for those we represent.
A strong call to action. And I sort of sense a step change in the attitude towards mediation with this change to the family procedure rules. It's been great to have you on the podcast, Marc, and I really, really appreciate your insight and comprehensive explanation of the new rules. Thank you.
Thank you, David. Appreciate it.
The Today's Family Lawyer podcast is available on your preferred podcast provider. It's also available on todaysfamilylawyer.co.uk. My thanks to Marc. Thank you as ever for listening, and we'll see you again soon.
You're listening to the Today's Family Lawyer podcast, the leading source of daily news and insight for family law practitioners in England and Wales. Sign up to our free weekly newsletter at todaysfamilylawyer.co.uk and subscribe to hear all the latest news and views from across the family law sector. You can also follow us on LinkedIn and Twitter.